very good morning to everyone. Thank you very much for joining this session. My name is Tânia Moreira. I am project manager and consultant at Inova Mais, Portugal, and also a partner of STARTS and specific STARTS Prize, the project that is pushing us to and allowing us to organize these kind of sessions. We are honored and with great pleasure we are presenting this and co-hosting this session with the IP Helpdesk, giving you this opportunity to clarify any questions on intellectual property rights. We are very glad, very happy to co-host this session because there are a lot of questions on this kind of topics, how to start, where to search for the right answer, and with lucky we will clarify most of our questions today with Michele Dubini. Thank you very much, Michele, for arranging the time to organizing this session with us. And well, I think we can already start. Just to mention to you one thing: this session is being recorded. After it, we will upload it in the YouTube, in the STARTS channel. If you want to rewatch, remind some, then you will have the opportunity to do that after the session. So, Michele, thank you very much. Feel welcome to this STARTS community. The floor is yours.
Thank you very, very much, Tânia. I'm very happy to be here. Thank you for the invitation and to have the chance to speak today. We are not many, but hopefully we're going to take out the most of our number as well, because in the fact that we are a handful of people allows you perhaps to make more questions also, if you'd like, at the end of the webinar, and so to discuss as well if you wish. So you have been muted anyway because background noises could be very harmful for the presentation. However, at any time you'd like, you can type your questions in the question part of the screen, and I can also stop and clarify the points that you haven't understood. So don't worry about it, just write anything that comes to your mind, because it's going to be a hint for discussion that I can gladly take. And if you have specific questions on the particular intellectual property rights that we are going to cover, very gladly we can clear your doubts. As I was saying, or as Tânia was saying, the webinar is going to be recorded, and also in case questions should pop out later after the webinar has taken place, or in case you watched again, simply write an email to our helpline in case you have questions, or if you're watching this webinar recorded, please write an email to our helpline in case you have questions that of course I cannot answer in the recording, definitely. Before we start with the actual content, which is introduction to IP and intellectual property rights, I'd like to quickly present to you the European IP Helpdesk so that you can understand who we are and what we do. I will also present myself out of politeness, I would say. My name is Michele Dubini, as Tânia has already introduced me. I am a lawyer and I'm specialized in intellectual property law. I have been working with the European IP Helpdesk for 9 years now, and I am part of the training team, meaning that I am responsible for the training of small and medium enterprises, researchers in EU-funded projects, and also beneficiaries mainly, in the sense that those three categories are the one that statistically ask us the most to receive the services, with whom, therefore, we have to deal basically on a daily basis. Nonetheless, the services you see on the right-hand side of the screen are open to all physical and juridical persons that might have questions regarding intellectual property and intellectual property rights. Basically, all the services start from the website, which is ec.europa.eu/ip-helpdesk, And on the website, you can find a large amount of publications that are there in order for you to download them and distribute them without any form of limitation to your audience or to your network. And also we offer training on a semester basis or individually, like we have done today. We also have an ambassador network across the European Union, and as I was telling you, a helpline, which is there actually to answer to all specific questions that users might have. And so it's a very good chance to ask for clarifications, basically because our experts are in Alicante and they are waiting for your specific questions. They will answer in the most understandable way they can, and most of all, like all the services we offer, they are completely free of charge. So at least giving it a try is never a bad idea in our case. Our territorial scope is the European Union plus COSME-related countries like the United Kingdom or Norway or Switzerland and Turkey and so on and so forth. In addition to that, we have our siblings active in the other different areas of the world like China, India, Southeast Asia, Africa, and Latin America. So if your questions are about IP in the European Union or nearby countries, we are the right target. Otherwise, if the questions go beyond these boundaries, our siblings are very happy to help you with that. They are embedded, by the way, in the very same website where we are embedded. So www.ec.europa.eu/IP-helpdesk. Just quickly, a couple of examples of publications we have. We have e-learning and modules and guides that are topic, country, and sector specific. There are infographics. There are case studies written down with the European Patent Office regarding, probably very interestingly, companies that have started by an R&D work. And so companies that in the most different fields of activities managed to turn their intellectual property into business and started therefore economical activities out of it. How they did it, how they organized themselves, what kind of intellectual property rights they have. It's all written down in these case studies. So very, very interesting. We have ambassadors, as I said, they might be in the vicinity of your premises. So just check out our website and see where they are based. Also, I'd like to introduce a further initiative, which is not the European IP Helpdesk, but it's very much connected to that, and it is free of charge, which is the Horizon IP Scan. The Horizon IP Scan is allowing small and medium enterprises that are part of a collaborative EU research project to be cited by an expert who is going to do a pre-interview with them in order to understand their specific questions, prepare himself or herself through a desk study in order to meet again the company in an interview of 3 hours where all the doubts are going to be cleared and where the company is going to receive concrete answers regarding intellectual property doubts with regards to the collaboration they are going to be facing. The website, you can see it down here. I just wanted to mention it just in case there are companies hearing this webinar or the recording, because it's free of charge and it allows the company to use the expertise of an expert in the field. These are our contacts again, so that you can write to the helpline in case you'd like to. Also, if you're watching the recording, that one you see there, helpline@iphelpdesk.eu, is your target for potential questions. Otherwise, there's our website and also the training account if you'd like to watch some recordings on our website. And then we start after this I hope interesting introduction, because it allows you to have a clue on what you can further use out of this hour and a half that we're going to spend together. We're going to start with the technical content, which is intellectual property and intellectual property rights. We will see the main mistakes that we could collect from from the cases we've seen and the questions that we have received by small and medium enterprises and researchers in the last 9 years, so when I've been involved. And also we are going to go through the main intellectual property rights and how what are their characteristics and how they potentially can be useful maybe for your services. We'll see soft IP, a little bit about costs of intellectual property rights, and then a couple of research engines that we normally use in our activities, and perhaps they can also be interesting for you. The first point, intellectual property. So the European Patent Convention defines intellectual property as intangible assets. So they are products of the human mind that cannot be touched by our hands, but nonetheless have a sort of value in the economical activities that we carry out, or also for ourselves. And so there's a big difference, of course, from the physical property, because we can touch a house, for example, we can touch a car, we can use it with our hands, whilst in this case, for intellectual property, we cannot really do that unless we take juridical measures, which are intellectual property rights. And here is the first mistake that we have realized by talking to people that are unexperienced in the sector of IP law, a confusion between the term IP and the term IPR. And that's something that can be easily corrected, but nonetheless, very often people do not find the chance to correct it, so the chance to know that there's a difference. So if I have described before in the previous slide intellectual property as the product of the human mind, so something intangible that we cannot touch, IPR instead are the juridical construction that the human being have invented in order, first of all, to be able to give a physical embodiment to this ideal creation, which is IP. And secondly, to be able to recognize without any doubt who is the author, who is the creator of that intangible asset. So on one hand, IP, which is the product of the human brain that we cannot touch, and on the other hand, IPR, which instead is the juridical construction invented by the human being that allow us to touch and understand the ownership of this immaterial creation. There are many types of intellectual property rights. Traditionally, the doctrine divides them between those that are called unregisterable, like, for example, copyright and its related rights. We're going to see later on what is copyright and what are the related rights to that. And on the other hand, the registrable intellectual property rights, so-called industrial property as well. These are the ones that, in order to start their protection period, need to be validated by a regional or national authority. They are trademarks, patents, utility models, and industrial designs. In between, we have the so-called soft IP, because if we need any way to publish the patent that is going to be protected after the patent application, because that's the social contract to which we sign up with the regional or national authority, we have instead other cases like trade secret, know-how, confidential information, where the actual fact that we do not publish anything allow us to have a economical advantage in the market by being a step ahead, because others are not able to understand or know how to carry out, for example, a certain process or a certain economical activity. So this is the so-called soft IP, and it's important to remember that despite being two different things, very often we are in front of a decision, for example, on whether to file a patent or to keep our information secret with a soft IP. And we'll see later on what are the pros and the cons of both of these systems and how to basically understand what is the best for our situation and for our business. One important question is, why should I care about intellectual property? Well, basically because IP is more or less all around us. We simply by connecting ourselves today, we have navigated through thousands of different intellectual property rights between patents, industrial designs, trademarks, trades. Them simply when you perhaps have Googled intellectual property or have Googled the European IP Helpdesk, you've gone through a trade secret, which is the Google algorithm. But then again, there's the Google trademark on the website, a variety of industrial designs on there. So it is basically all around us, even if we do not realize it. And most importantly, in our day-to-day business activity, we use it. And very often we actually don't even know that we've entered license contract. That some of them are of course free of charge, some others might be not. So we need to pay attention to this, especially when we start commercial activities. It happens very often, and we will see later on in the slides that companies breach intellectual property rights without even knowing that. We will concentrate ourselves on protection on this webinar, but there are other steps that the management of intellectual property assets require, like management and enforcement. And it's important always to remember that, because protection per se is just a cost for the company, and the management instead is what can bring revenue out of the registered intellectual property rights. So, for example, when we look for potential licensees that might be interested in our technology, and when we license that out, we are making a profit based on the protection that we did before. But if we only have a patent and we keep that in our drawer, it is going to be a cost and nothing else for our company. Because we will spend quite an amount of money to register it in patent attorney fees and examination fees, and then we are also going to have to keep it alive, meaning that every year we will have a fee in order to keep this patent alive. And these are all costs. If we only concentrate on the protection and not on the management and potentially the enforcement, we are not going to profit for it. We've got many webinars dedicated also to the management of intellectual property rights. I will contact you later on with a follow-up email that will also contain the slides of this webinar, and you'll have the chance to visit our e-learning page and check out other webinars that are potentially interesting for you regarding management activities of intellectual property rights. Now, as I said, we are going to concentrate on intellectual property rights and all the IP protection tools. So we always need to remember the first difference between intellectual property and intellectual property rights. And so to this, I would like to add that not all intellectual property rights can be applied to all intellectual property that we generate with our brain. And so IPR, like patents and other utility models, are applicable only to inventions, whilst industrial design to innovative designs and brands to trademark, for example. And so we need to pay attention what we choose for what activity we basically have, because if we try to protect a certain IP with the wrong IPR, we will not succeed in our activities. So before start describing the different intellectual property rights that I would like to bring to your attention, I would prefer, and actually I'm going to explain to you the general principle that are at the basics of IP law in the European Union, but also outside. The first principle is that IP rights are territorial rights, meaning that a certain protection is applicable only in the territory in which you have applied for protection and not outside of it. So let's say, for example, that I have a very good invention. I'd like to have a patent protecting that invention, and I file for my patent in Italy, and maybe also in Spain and France and the Netherlands. Once the national authorities have examined my patent application, I will have a granted patent. However, I will have a granted patent only for the territories of Italy, Spain, France, and the Netherlands, which means that other regions like the United States are going to be left outside of it. And anyone interested in the use of my invention in the United States is going to be able to do that without any form of limitation. So on one hand, having too few countries or regions protected where my invention is protected could be a problem, in the sense that it limits the protection range of my invention. However, the scope of the protection is directly proportional to the costs that I have to undergo in order to receive protection in at a larger scale. So it will be more expensive to have it also in the US, in Russia, in India, in Africa, in Latin America, and so on and so forth. So we need really to think about where is going to be very useful for me to have the invention filed and granted, so the patent file or other intellectual property rights, depending of course on the business that I'm going to do. If I know that I'm never leaving the European Union and that in the US is not really a market of my interest, then I'm going to limit the cost and stay in the EU. That's very important, however, also under another point of view. For example, let's say that we are going to commercialize a certain product, and we wouldn't like to breach anybody else's right. And so we're going to check whether there are, for example, patents regarding the very same topic active all around the world. We find a couple, but we see that they're all granted only in the United States. That's perfect for us because it means that we are free to operate in the European Union. So we need to check it under these 2 points of view, these 2 faces of the coin. When we want to use a certain technology and check that it is not protected or not protected in our area. And then when we would like to avoid somebody else or prevent somebody else from using the technology, and so try to foresee what would be my areas of interest in order to have the protection. The principle of territoriality, therefore, is very important. And then there's the passivity.
Michele,
Yes.
may I have a question? And how can we check? How can we check this territorial? Do you, for instance, the IP Helpdesk can help the businesses to do this checking?
Yes, we don't carry out directly the search. They can be done by patent attorneys, for example, but if you know the technology, and let's say that you are a company active in the field or a researcher, you probably know the technology, and you can use websites like research engines like eSpaceNet, for example, for patents, or Trademark View for trademarks, and see where companies might be active in the different areas of the world, and a Design View for industrial design. These 3 research engines are completely free of charge.
Okay.
And can be used by anyone, so to say. Actually, eSpaceNet is the largest catalog of technical documents currently present on Earth, with more than 80 million documents saved on, and by document I mean patents, actually saved on the database. We are also organizing potentially a new webinar in the second half of the year completely dedicated to this topic, which might be very interesting. I will write that to you. We are in contact with a patent attorney at the moment that is going to explain all the hints and tricks of his work when he's doing this kind of researches, and also show how to use proficiently the tools, because there are basically two types of search. There's the basic search where, let's say, it works like Google more or less, where you type in a key term and all the connected dots and documents are pulled out. But it's quite large, and the results are not really always satisfying. Whilst instead there is the advanced search as well, where you can, for example, search for couple of words that are in the vicinity of each other, where, for example, they are within 5 words from one another, therefore, let's say, sharpening the range of your search. So all these methods and techniques perhaps are a little bit less known, especially for those who are not of the field, and that is what we would like to clear through this webinar a little bit, give a couple of weapons more to those who are approaching these research engines, so that they can have more satisfying results, so to say.
Okay, cool. Then if you can share this information, for instance, the links for these 3 websites where we can do
our own
research.
Definitely.
And also information on the webinar that you will host in the next month. That would be cool. And for the ones that are watching this recording, we will put the links on the description of the video, so you can also check the links and, of course, attend the webinar to know more about what we are talking about right now. Thank you very much.
Gladly. So the webinar is still in organization phase. I don't have the dates, but as soon as I will have it, I will send them to you. And the recordings links are going to also to be in the follow-up email. So no problem about that. Gladly. And then there's the second principle, which is very often misunderstood, and we've seen a lot of mistakes by researchers, mainly writing to us with their question, is the principle of the passivity of the rights of intellectual property rights. So just to give you an example, we had a few months ago a researchers writing to us and saying, how is it possible that after that I commercialized or licensed this technology to another company, a big pharma has been writing to this company saying that they should cease and desist from using that technology because a part of it is patented by that big pharma, and they are breaching their patent. They're saying that is not possible because I had a patent, therefore I had an allowance to operate in the market, I was free to operate. This is very wrong, and this is very dangerous as well, because if you get a patent granted and you think you can do whatever you want in the market just because you have that particular document, you're going to make some serious and potentially costly mistakes. In fact, the patent or other intellectual property rights are simply a passive right. They mean that you can prevent others from using, commercializing, importing, exporting that particular intellectual property right for a given period of time. So please do not think that having a patent allows you to enter a certain market just because you think, or basically what you have is new. Because, for example, in that case, the compound that was patented was using other pre-existing compounds already patented and mixing them for a new result. Well, in this case, when you commercialize, you cannot avoid using the other compounds that are already patented. And therefore, you are basically selling a product that is using others' technologies without their consent. So you are breaching their patent despite having your patent yourself, because your compound is new, inventive, and has industrial applicability. Maybe this point is a little bit more harder to grasp, but just to summarize it, a patent is not an allowance to operate in the market. A patent is only a right to prevent others from using the technology that we have created. And like this, all other intellectual property rights. And additionally, the duration of the protection. Basically, all intellectual property rights have a limit in time, and that is because their objective is to foster innovation. If we would have unlimited protection for unlimited time, then we would hinder innovation, because nobody would basically be able to use them anymore. For example, patents after 20 years from their patent application expire, and there's nothing we can do in order to increase their lifespan. The same for industrial design. Also copyright, it lasts much longer because it's 70 years after the death of the author, so it's a very, very long time. And also trademark normally lasts for 10 years, but the difference here is that we are able to renew trademarks as long as we want, provided the fees are paid. And that is fine, because trademarks are the characteristical, the way we see companies in the market. And so if after sometimes everybody could use, for example, the Coca-Cola logo, it would be a problem not only for the companies but also for consumers. Another very important principle is that intellectual property rights can be used in a combined way. So when we see a product, for example, the shoe in front of us, very rarely we will have products that contain only one intellectual property rights. Very often, instead, they will contain a multiple variety of different intellectual property rights, like we can see here: patents, trademarks, designs, and copyright as well. But it is interesting to see that their used combined allow for the perfect protection, so to say, that the company is aiming at while filing all intellectual property rights. Also, I'd like to take this picture to explain the example I was doing before regarding the passivity of the right. Let's say that I am the inventor that has created this, let me just laser point it. I hope you can see it. I have created this patent here, so the one in the bottom left, and I want to commercialize my shoe here. Because I think this is a great invention. It keeps my foot much drier and cooler, and so I think I have something incredibly nice to put in the market. Even if I know that maybe I wouldn't be able to use the Nike trademark, and I can understand that, and I'm not using it, I'm just commercializing my shoe with another trademark, I basically take this shoe and put my invention in there, in the sole of the shoe, and I commercialize it. After a couple of months, probably I receive a couple of angry letters that say that I am breaching this patent that we can see up here, so the other part of the sole, this other patent here that is on the laces, these other patents here which is on the texture of the shoe itself. And maybe I wasn't even aware about that, because I bought the basic shoe from a third party, and then I thought I could start commercializing it, or I just allowed an artisan to make it without any form of authorization from the owner of the original patent, and then I have done quite a damage, because now I'm not able to sell my product anymore, because despite my patent being original and new, I have other patents in the product and designs that prevent me from doing that. So this is another example of visual example, I would say, of what I was trying to tell you before that maybe was a little bit harder to grasp among the first principle that I have introduced. And so, yeah, many ways to protect. Best ways, however, are the ones that use intersection between different intellectual property rights, depending, of course, on the product that we have and that we would like to use. And now let's talk about the individual different rights, starting by the most famous, so to say, patents. So let's allow me please to read the definition, because it's quite interesting and also takes over what we have been talking before. A patent is a title providing the inventor or the applicant with the exclusive right here to prevent, so here the passivity of the rights, others from possessing, using, selling, manufacturing, and importing the patented invention, or offering to do any of these things within a certain territory. And here comes the principle of territoriality I was introducing before. And down on the right hand side you see the principle of duration, so 20 years. A common question we receive is that how can I understand or know what can be patented? We can patent inventions, and inventions are the ones you can see here, the patentable subject matter. The European Patent Convention describes negatively what can be considered as an invention. So the legislator is telling us we cannot consider as invention discoveries, scientific theories, mathematical methods, aesthetic creations, scheme, rules, method for performing mental acts, and programs for computers as such, as well as presentation of information. Then if we are not in the last 4 points and we are not in the last 3 points, so we don't have a method for treatment of a human or animal body, we don't have a plant or animal variety, and what we try to patent is against public order or morality, we can actually we have in our hands an invention that can potentially, at least for the first requirement, be patented. However, then we have other requirements, which are novelty, inventive step, and industrial applicability of the patent. So novelty is, again, the legislator that says that this invention that we have in our hands does not have to form part of the state of the art. The state of the art is everything that is available to the public before our patent application. This is very important because let's say that we are researchers and we need to publish because that's basically our job. And we, however, suspect that what we have in our hands could be something patentable and interesting. So we are aware that what we need is to be novel. And so what we do before we publish, we file a patent application, because even if before the patent is granted, so if we have only the application and the patent has not been granted yet, we publish in that period of time or even after the grant, the examiner is not going to be allowed to take into consideration what has happened after the patent application. So this is our bar where we basically keep ourselves safe, and then we can publish or disclose everything we want. If instead we publish, disclose, or even make a video on our invention and show it before the patent application, then we are not going to be able to patent our invention anymore. A very interesting example of this is the swipe of the iPhone. I think this invention down here, well, it's not like that anymore, but before it was like this. Steve Jobs showed that in the presentation of the iPhone 2 or iPhone 3 before the patent application actually was filed for this. And the examiner at the USPTO actually used that presentation in order to tell him, or to Apple, to tell to Apple that the invention was not novel anymore because the founder had used it and showed it worldwide during the presentation of the iPhone. So of course this might not be the case, but also a simple video on YouTube, even if it's not watched worthwhile or does not have millions of views, could be novelty breaking in the eyes of the examiner. So let's say we have an invention. This invention is new because it's not part of the skill of the art. The examiner is also going to check that the invention is not obvious for a person who is skilled in the art. The person skilled in the art is a fictitious person who basically knows everything about that particular art or science, but that does not have the inventiveness to make a further step, so the malice, also the cleverness to make this inventive step and create the invention. So to give you an example, an invention is obvious. For example, if we have something that is new, but just because we change a little detail. So I had an invention, for example, made out of plastic before, and I make the very same invention made out of wood. Except for specific cases in which it was, let's say, impossible to think that that invention was done carving was possible to be done by carving woods. This invention would be considered obvious because anyone could have thought that what works with plastic basically also works with wood. So just changing details of other inventions or creating something that is actually obvious for a person skilled in the art. And finally, the last requirement, probably the easiest to grasp, is the industrial applicability. That says that invention, if it's new and inventive, is going to be patentable if it can be reproduced on a industrial or agricultural scale. So for example, a work of art would in no way be patentable because we cannot simply reproduce it the same way we have created it. A couple of examples for patents. Here, this swimming suit was created by using a particular material that allowed swimmers to win valuable seconds in competition. Actually, there was an Olympics in 2009 where basically all world records were broken because it was a matter of seconds, which were a lot at those level, and many of them now have been banned because of the great advantage they provided to the swimmer. Or also some other inventions like the human sensor that tells you how the quality of the air you're breathing is simply by showing it in the colors of the application itself. Now, the registration of the patent, because I told you territory is important. So there are many different routes that we can choose, either national. So let's say I'm in Italy, I'm going to file my patent in the Italian territory, and I will receive protection only for Italy. But I can also choose the European route, where I'm going to have a bunch of patent applications, and they are going to be validated in the countries in which I would like to have them validated. So I translate my patent application, and then it's going to be examined centrally in the European Patent Office and validated in France, Netherlands, Spain, UK, depending on where I would like to have it validated. The same happens for international registration outside the European Union. So I can have my exam and validation in the United States, exam and validation in Brazil, Russia, and so on and so forth. From this year, however, we have a new way of doing this in the European Union that can allow us basically to select a multiple number of countries within the European Union and having one single document for all these countries. You can see here in blue. Unfortunately, we don't still have all European countries on board, and Spain is seen to be quite outside of it and not coming in, the same as Poland, but others might be joining very soon. And the advantage of the unitary patent with European patent with unitary effect is that we don't need to provide registration anymore. We don't need validation from the single national patent offices, and so we have one document that costs less and covers more territories within the European Union. But of course, the United Kingdom is outside, as you can imagine, and other countries still have to join. We keep our finger crossed that we can actually manage it as soon as possible. There is one register, one renewal fees, because that's also important to remember. As I was telling you a couple of minutes ago, if we have a patent, we need to keep it alive. And so if we had chosen before France, Germany, Italy, Netherlands, we would have 4 fees to pay in all these countries. With this new system, instead, we're going to have 1 fee for Portugal, France, Italy, Slovenia, Austria, Germany, the Benelux, and Denmark, and Sweden, Finland, and the Baltic states, plus also Bulgaria down there. So it's an improvement, definitely, but we still have to come to the best system possible, and but that's the way, and hopefully we're going to be able to do that. Another mention regarding utility models, because in many countries of the European Union, if we have inventions that perhaps are not, let's say, clever enough to be inventive, as we were analyzing before, we could still have them registered only in the country where we are based as a utility model. A utility model protects the so-called minor inventions or those inventions for which we really need fast protection for because the process for granting is much faster than it is for traditional patents, and they are also much cheaper. The point is that not every country in the European Union offers this kind of protection, and there is no way to have a European coordinated protection. So if we would like to use this system, we would need to file in all different countries of the European Union in different languages and so on and so forth. So there are, of course, shortcomings to the system, and this is a comparison. Patents have worldwide novelty, whilst utility models only have national novelty. I was telling you before, if, for example, with the invention I have was published already and described in Japan, and I would try to file the patent in different countries of the European Union, the examiner would tell me, I'm sorry, but your invention is part of the worldwide state of the art because it was published in Japan a few years ago, and I cannot allow you to file. Whilst, let's say I'm only with my utility model in Italy, the examiner is going to tell me, okay, in Italy, the national novelty is proved. This document was published in Japan, so it doesn't count. This is a good advantage, I would say. And also the fact that the inventive step is lower and the application process is faster, and the registration is cheaper. However, the protection is shorter, as you can see, and not as wide as for patent. This is very important to remember, but still utility models are a potential method for protection. And then I'd like to spend a few words regarding industrial designs. Industrial designs are the way we use to protect aesthetic features of a product. And they concern merely the appearance of the product. So I take usually the example of the outside part of a car. So they are protected as industrial design because normally we don't care about performance for our cars that we use every day, and they don't have any technical features on them. However, Formula One pieces or NASCAR pieces also have technical features on them. So in this case, we see how the combination of intellectual property right can be used in order to create the perfect protection. So the appearance is protected by the industrial designs, whilst the technical effect that, for example, enhances the aerodynamics of the car is protected instead by a patent. Again, industrial designs need to be novel, so the design cannot be copied, definitely, but also a little bit more further, it has to have an individual character, so it must look different from any other design that has already been created in the past. The maximum protection here is for 25 years, and it is renewable every 5 years. Here, instead, we have a simpler system for registration. We can choose the national way, for example, Italy, as I was saying, or we can go directly for a European Union design that covers all the countries of the European Union, which is in what I was trying to tell you before, what we would like to reach with patent as well, but we haven't reached yet. The central office of the WIPO is in Alicante, in Spain, and they coordinate the registration for the European Union designs, valid throughout the whole European Union. And finally, there's also the international route that works like the international routes for the patent, where we can go outside the European Union. These are a couple of examples of designs. So this Vespa looks kind of strange and certainly different from every other Vespa, or let's say its seat looks different. It doesn't have any form or any kind of technical advantage from it, but the way it looks really hits the consumer, the user, and so it is protected as an industrial design. The very same principle is valid for that juicer or run juicer or lemon juicer, whatever. It looks like a spaceship, but it doesn't fly, definitely. So that's the reason why we can protect this with an industrial design. It doesn't really have any technical feature, but it looks very impacting for the consumer, and so nobody else basically will be able to reproduce that particular design the way it is. And that is very much used, if you think about it, in house designing with furnitures and so on and so forth. Then we get to trademarks. Trademarks are a sign or a combination of signs that are used in trade to identify and distinguish the goods or services. So think about getting inside a supermarket without trademarks. Everything would be white and it would be impossible for us as consumer to understand what we're buying or what we have bought or what we would like to buy in the future. A trademark then is a way that we give the consumer to identify the certain entrepreneur or company that has created a similar or same good or service that they had bought in the past. This allows the entrepreneur to build on the quality basically that he has delivered in the past to consumers. And we also need to remember that the trademark can be used in the relation of only certain goods or services. Only certain goods of services in respect to the NIS classification. So we basically have 45 different categories, and some of them are for goods, some other are for services. If you check out the Wikipedia also and search for NIS categories, you can see all the different categories for trademarks. They are important because when you're going to want to register a trademark, you will be asked to select the specific category for which you would like to have the trademark registered. And in addition to this, you will also have to pay 50 euros more for each category that you are going to select. And so being 45, this could be a very large leap in the price of your trademark. Don't think also that only logo can be trademarks. In fact, there can be words, letters, picture shapes, colors, and even smells can be trademark. We also have 3D trademark. A couple of examples here. This is the Jack Daniels bottle. Everyone I think I know it. This is the Coca-Cola bottle, the package for fries from McDonald's, and so on and so forth. There are requirements for trademark registration, so that the trademark needs to be distinctive, that we can recognize it. It does not have to be deceptive, so saying imply certain characteristics when actually they're not there, lacto-free for regular milk. It doesn't have to be descriptive, because if it was descriptive, we would be taking away useful words also to the competition in the market. Restore for medical instrument or apparatus, for example. It does not have to belong to the exclusion provided by the law. And for example, if I would be able to register the Italian flag as my trademark for pasta, for example, it would be a real problem for all pasta producers all around the world. So countries' flags may not be registered. And also it has to be in conformity with public order and morality. The central office of the EU IPO controls these points here and will not allow us to register a trademark that is against these principles. Trademark registration works exactly like the design registration. Actually, they have the very same office in Alicante, Spain. So here again, we've got that situation that we would like to reach with the patent system, having one single right throughout the whole European Union, and then an international system if we want to go outside the European Union. Then I'm going to be finishing with a couple of info regarding copyright, soft IP, costs, and how to search for intellectual property rights also, although we talked about this a little bit before. I think, however, copyright is important, especially for researchers, because it is used to protect the intellectual property that we create and that we publish. So copyright does not protect ideas themselves. This is a common mistake that it is done, but it protects the concrete form of expression of such ideas. And the works can be protected as long as they are original, and it's interesting the fact that no formal registration process is required, so unregistrable, as we were saying before, because protection starts from the very moment in which the work of art is completed. So if we write a book or a paper, we're going to have copyright protection from the moment in which we have finished writing that paper, and that copyright protection is going to last for my whole life plus 70 years after I'm dead. So it's a really, really long time. When we analyze copyright, we need to know that there are two kinds of copyright. So let's say the copyright rights divides into branches. The one is the copyright itself, that is the right of the author to be always recognized as the creator of the work of art. But on the other hand, we have the so-called economical rights or related rights, that are the rights that apply to the work of art, and that can allow to do certain activities, like, for example, performing it in public, translate it, adapt it, and so on and so forth. Copy or reproduce, distribute to the public, perform in public, translate into other language. So the copyright holder may never alienate the copyright itself, so the right of being recognized as the author of the work of art. However, he or she, let's say, can sell or rent these other rights, like the right to copy or reproduce the work of art, or distribute it to the public, or perform it in public. An example of this is, for example, Lord of the Rings. The work was adapted from a novel to screenplay, and the author or the company behind the author was paid for the right of being able to adapt it and so on. There is no registration required. However, we can have a proof of ownership. So let's say your right starts from the moment in which you finished your work of art. However, you would like to be 100% sure that you can, for example, show a judge that on the specific day in which you have finished the work, that was the specific day, so that the 29th of June 2023, I had finished my book. And I can show it because on the 29th of June in the afternoon, for example, I had registered it on iDepot or Envelope Solo or WIPO Proof. This way, we're going to have a free of charge and very easy way to prove that actually on these days I had finished my work. That can be useful if somebody is saying that they had also done the work of art and that they had done it, let's say, on the 1st of January 2024, and they can prove it, but we cannot prove, for example, that we had already finished it on the in June 2023. Now I mentioned regarding soft IP. Soft IP, we don't have a specific definition, but soft IP is that business information that that provides an advantage to the owner as long as it is kept secret. And so if we can keep it secret, then it is a good idea to have a trade secret and profit from it, because there is no limit in time. Very often we receive the question, should I use a patent or should I use a soft IP like an trade secret? The answer, unfortunately, is it depends on the case. And to explain this, we normally take two very different fields, like the automotive field and the research engine fields. For the automotive, we basically never see trade secrets, because if you buy a car and, well, nowadays it's harder, but still you can see how the inner pieces are, and maybe you can replicate them and use it for your chain of production. If that information was protected through a trade secret, well, there would be nothing preventing that person that bought the car, understood how it works, replicated it, and used it in its production chain. If they would be free to do that. However, with a patent instead, the automotive car company is showing everyone how to do this. However, it is receiving back by the system, by the legislator, the possibility of excluding those others or everybody else from using that particular pieces unless they pay something to the company. And this is the core difference between the trade secret and the patent. We share and show with the patent but prevent the use, while trade secret does not show anything. But in the moment in which anyone can reverse engineering what we had created, then we have no protection anymore. So we need to pay attention to all these points. The other example is the Google algorithm. Google has no patent on its algorithm. However, when we use Google, we simply put information in a black box and receive other information out of it. So yes, we have no way of reverse engineering the way the algorithm works, and therefore it is simply kept secret and not protected by patent, because this way they can have their protection indefinitely in time. The costs, and we're getting to the end of this presentation, I promise. Patents may cost differently nationally in the different countries. At the European level, now with inflation, maybe a little bit more than 5,600 euros. However, with the patent attorney examination and everything, we should be about 10, 11, 12,000 euros. So they are expensive. Definitely. Between all the intellectual property right, patents are certainly the most expensive. Trademarks also can be filed at the European level, and they cost 900 euros plus 50 euros for each category that we choose of the 45 I was telling you. So they're cheaper at the end. Even cheaper are industrial design with 350 euros across the European Union. And finally, the monitoring and the searches. So the three research engines that I was telling you before are useful because they can allow us to retrieve information regarding patents, regarding trademarks, and regarding industrial designs. But these information are not there for us only if we want to file a patent and we need to know who is holding information and potentially could hinder my activities. This information in there actually can be also useful actively, because if we open up let's say eSpaceNet and we search for a certain technology, we can have many useful information regarding the producers of that or the assignee of that patent, and so the holder of the document, who they are, who are the who are the inventors behind the invention. And so we can have a panoramic, so to say, on the technology that includes all companies or research centers or inventors and researchers that are involved in that particular technology. It can open up doors for networking. It can open up doors for commercialization as well, if we think we could be useful to their activities and to their technology. So I told you before, we use eSpaceNet to search and make patent search and see whether there are potential obstacles in the market. But you could also use it even if you actually don't have a patent to file, but you would simply like to see who could be a good partner in that particular field, for example. And so I wanted to mention this because very often the questions we receive are we need to check for our novelty, we don't know this and that, and very few people think about the fact that they could retrieve information, as I said, from the largest database of technical information on Earth. So that's something always useful to remember. And also a couple of other researches on trademark, copyright, trade secret, inventorships. You can find all the charts and the fact sheets on these documents in here. And with this, I'm at the end of my presentation. I have left, as planned, 15 minutes for your questions, and I'm very happy to answer to all these questions. Thank you very much for your attention. And thank you, Tanya, also for your attention.
Thank you very much, Michele. So if the audience has some questions, this is your time. Take advantage of this.
Gladly, yes. Or, as I said, you have here the helpline account. I think you can still see it, yes.
Yes.
And if you're watching the recording as well, simply write to our helpline and they will provide you with an answer within 3 working days.
Okay. if anyone doesn't ask questions, I think we can finish this session. Thank you very much, Michele, again for sharing all this very useful information with us. It was really helpful, I think. And please, to the ones that are watching the recording, visit the IP Helpdesk website. They have a lot of information there as well. They usually host webinars and other kind of events on these different topics. Michele earlier said that they are organizing a specific session on a topic that we thought that would be also useful for you. So pay attention on the event agenda, because they put there all the events they are organizing. And well, I think that is it. Thank you very much, Michele. Thank you very much, the audience.
Thanks to you.
Also keep following STARTS in starts.eu and also the social media. Next month, we will also organize STARTS sessions. Take a look on the STARTS newsletter and also the website. We will share information on the next sessions very soon. Thank you very much. See you soon, I hope.